First, it represents the most comprehensive catalog of the criticisms of originalism that can be made from the point of view of its failure to take account of diverse voices. Beyond that, it's one of the best reminders I've ever read for originalists to consciously focus on how their own ideological biases may distort their reading of the Constitution. After reading this paper, in fact, I've tried to resolve always to make an early effort to see if I can interpret a constitutional provision that I'm investigating in a way that would be favored by someone opposed to my own ideological priors. That kind of thought experiment, I think, can be a valuable check against bias. But let me move to a few suggestions and concerns. First, I think the paper would be helped by distinguishing more sharply than it does between the problems that diverse voices creates for positive originalism as opposed to normative originalism, between the issue of what the Constitution means at the time it was enacted and whether we are bound to follow that meaning today. Positively, the soundness of the analysis of original meaning may be distorted by ignoring diverse voices. Normatively, the absence of diverse participation in the framing of the provisions may undermine the attractiveness of originalism. On the positive side, I have two kinds of concerns. One is Professor Mulligan's standard of evidence for determining original meaning. She argues that the reasonable person standard has bite only insofar as it excludes idiosyncratic voices, but not if it excludes interpretations that are shared by a community. The example she gives is one in which the Anti-Federalists allege that the Copyright Clause gave the federal government power to license the press. She acknowledges that this interpretation may be in tension with the text of the clause, which says nothing about the power to license, but instead gives individual authors rights to their own writings. Nevertheless, she suggests that if the community of Anti-Federalists believed that this was the meaning of the clause, it's plausible, and it really shouldn't be discounted by some characteristics that a reasonable person may impose, like consistency with text and coherent logic. I'm not sure her conclusion is right in this specific instance, and it provides a window into why it may be wrong to largely reject the reasonable person standard, which in my view is a good first approximation for how lawyers have traditionally searched for legal meaning. First, logic, coherence, and above all consistency with text are now, and were then, salient aspects of legal interpretive methods. But these kinds of constraints imposed by a reasonable person standard would be chosen, I think, even under a veil of ignorance as to what interpretive standard should have been. They are important for testing the seriousness and sincerity of historical claims about meaning. These historical claims, after all, are simply testimony about meaning, not the meaning itself. For instance, in this case, the Anti-Federalists were arguing the First Amendment was needed to supplement the Constitution, and thus their interpretation may well have been strategic. The larger point is that to ascertain the empirical fact of meaning, we must take account of the weight of testimony, no less in considering originalism than in testimony about any other empirical facts, like what happened in an accident down the street. The coherence with other facts and the logic of testimony is always relevant to its weight. Nor do I think it's necessary to jettison a reasonable person clause to avoid infusing our values into originalism, as Professor Mulligan suggests may have happened when Scalia used a modern understanding of the interpretive relevance of a preamble. It's the reasonable person at the time that counts, his logic and the rules of interpretation applicable then. If Scalia relied on a modern view of the preamble, it was simply not following the interpretation of a legally reasonable person at the time. Even were interpretations shared in a group sufficient to create a valid interpretation of the Constitution, even if they weren't reasonable, I don't think Professor Mulligan has made the case that diverse voices are likely to change our analysis of constitutional provisions, at least very much. First, she has not shown that language generally means different things to different groups as divided by race, ethnicity, or gender. Now, it's possible if interests are sufficiently different, such divisions can systematically pull apart what language means to each group, but that needs to be shown. I'm skeptical, at least, that the interests of men and women in 1789 were so very different, given that women were dependent on the earnings of their male relatives. Indeed, actually, there seems to be some evidence that when women were given the vote in New Jersey in the early 1800s, they voted much like their male relatives. But perhaps that does suggest that it would, in provisions after 1789, there might be more opportunity to see this divergence. And if one believes, as I do, that the Constitution is written in the language of the law, it's even less likely that diverse voices will make much difference, at least as to the many provisions that crucially reflect that language. The language of the law was built up over centuries through legal practices which are simply not the domain of diverse voices. That may or may not add to the normative problems for originalism from diversity, but it does make these voices less relevant as a positive matter. The leading examples of diverse voices Professor Mulligan includes may in fact undermine our case for their potential importance because they aren't likely to shift relevant interpretation today. As Professor Mulligan herself admits, Absalom Jones' interpretation of the Constitution's relation to slavery is essentially moot today. And the petition on the militia power, arguing that the Privileges and Immunities Clause of Article 4 protects against racial discrimination, seems very unlikely to change the range of plausible interpretations of that clause. That failure, I don't think, comes from the fact that originalists would discount these voices because they are diverse. They would discount dominant voices that said the same things because the interpretation postdates the Constitution by 2 generations and because it conflicts with the plain language of Article 4. I don't doubt that these are matters of great historical interest. I'm not at all dismissing them in that sense, but I don't believe they help advance the case that diverse voices will be interpretively important. As I said, Professor Mulligan's catalog of the normative criticisms of originalism made on diversity grounds are wonderfully comprehensive. But in my view, it might be a slightly more interesting catalog if it was a more discriminating one, shifting the powerful from those that seem a little feeble. For instance, arguments that originalists are manipulating originalism consciously or unconsciously to get politically favored results are not a criticism that is unique to originalism, but can be made about any theory of interpretation. And one might, in fact, argue that the fact that originalism is grounded in empirical facts offers at least some break against these biases as compared to other theories. Now, as of course, I talked to Mike Rappaport, as I always do, and he made a very good suggestion to me when we chatted about this paper. He said that I'm probably not among its prime audience. I'm a white male, and I'm an originalist from the time I went to law school, maybe a cradle originalist. Thus, I end by trying to enter into the spirit of this very interesting paper and fine paper by checking my biases and trying to consider how I would regard this paper as a diverse non-originalist. On that reflection, however, I'm not at all confident that I would gain much more sympathy for originalism, even were originalists to take diverse criticisms more seriously. To be sure, I would take on board Professor Mulligan's excellent points that public meaning originalism divorces to some extent the intentions of particular founders, which we may find odious today, people we may just really find objectionable, and that its transcendent meaning can rise above bad historical associations. That may indeed help with the sense that this is just an alien document. But there remain stubborn facts that I believe are stumbling blocks to persuade at least the diverse scholars who are progressives of the importance or of the power of originalism. And frankly, as a recent paper recounts the ideological uniformity of the legal economy, women and minority law professors are substantially more on the left or the progressive side even than other law professors. First, it's hard to avoid the conclusion that the Constitution is almost entirely a charter of negative liberties against the state. When progressives in other nations have dominated the framing of a Constitution, they tend to include positive rights, and diverse progressives might like to see group rights to supplement individual rights, and these are just absent from our Constitution. The Constitution also has a variety of structures that slow down change, like the separation of powers and federalism. And the amendment process is consciously laborious. Not surprisingly, then, progressives, I'd say from Thomas Paine onwards, have chafed against restraints on fashioning the world anew against the oppressions of the past. And one characteristic, in fact, one defining fact, I think, of diverse progressives is that they believe the burdens of past gender and racial oppressions distort greatly our present institutions, necessitating radical change. Thus, I fear that for any diverse progressive professor, at least for the great majority of them, this paper, for all its sincerity, its creativity, and its power, is sailing against some pretty strong headwinds.
Thank you so much, John. Those are all really important comments, and I'll only touch on a few because I want to hear everyone else's thoughts. So one about the reasonable person. One thing, and I was talking to Evan right before this session started, and so one thing that I think could be clearer in the paper is that looking for qualities that we think of as reasonable is not necessarily wrong-headed, but that I would urge that we do what John just did by saying, by reasonable, I mean we want the text to be internally consistent for these reasons, and then by stating why we have these normative values about how to interpret the text, we are opening ourselves up to putting pressure on whether that's the right thing to go for or not. And by bringing that out explicitly, we're not accidentally hiding what might be a bias or an assumption that we might want to think about in a different way. I accidentally dropped this sentence when I was revising the paper, but when I was talking about Mercy Otis Warren, I originally had in the paper that seems fairly probable that there was a large overlap in the views of elite white women and elite white men because they shared similar discursive communities a lot of the time. And you see how Mercy Otis Warren's pamphlet was thought to be written by Elbridge Gerry for over 100 years. So that, I think, is a valid critique. About whether this will have interesting practical implications, there's very little written by non-white authors in the founding period, and also still not a lot by white women. But as you move towards the Reconstruction era, you see a lot more. And I was talking to Jack earlier about the new departure in suffragettes' interpretation of the 14th Amendment. And so where you have communities that really have a discursive culture among themselves, I think and evidence that is preserved later on in time, it seems quite plausible that there are different opinions and different discursive immunities that might actually conceivably make a difference in outcome. I will leave on the table whether anyone who is not an originalist will be moved by this and go to the comments from the room.